Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I am delighted to review a book I've done before. It's one that I think is very, very important, and it's in an area of law which I know a lot of people are interested in, from trade union officials to ordinary members of the public to certainly to legal professionals and advisors, and of course anybody who runs a business. It's health and safety. This is the Law of Health and Safety at Work annual. It's now the 25th edition for 2016 to 17. It's now been edited by Rachel Moore, and it's been published by Wolters Kluwer in Kingston. Now this is the book here. I've reviewed it, as I say before. There's the front, there's the spine, and then there's the back. Now it's a compact paperback, and it's an annual book. It's been updated very substantially for this year. The back of it is the index. It is done by paragraph numbering, so you can find the information quickly by the paragraphs. The index is actually a big index. It's a subject index, and it's quite substantial at the back. Then you've got, after that, a number of lists, various appendices, and then we go to the front of the book. The text was originally written by Norman Selwyn, but this goes back quite a long way because the first book was published in 1982, just before I actually started reading for the bar. I'd been qualified, but I hadn't actually become a barrister by then. There is the foreword. Well, it's a long time ago, written by Teresa Budworth. There's a preface there which is well set out by Rachel, dated September 2016. Then you've got the content section as a whole. Very detailed information here for the various chapters. It starts with the law and legal institutions, then runs through from that to there are 14 chapters in total, and there are 3 appendices. The appendices, of course, have useful addresses, publications, and EU directives. Notwithstanding, sorry, there are 4. There's an appendix D, which is glossary. Can I just say, notwithstanding our decision to leave Europe, it's not going to affect us for some time. This is, so don't worry about that. This book will take account of that. This is the list of statutes, because it's very much statute-based. Excuse me. And then you've got, after that, tables of regulations and orders. There's a lot of that, of course, for this particular area. Then tables of cases. As you know, readers of the Daily Mail won't be too happy with some aspects of this this particular area of law, but I still think that this book, which Rachel has produced, that's the case law there, is really first class because she puts it in nice, understandable terminology. Starting off with chapter 1. There we go. Law and legal institutions, the background to where we are. Because everyone thinks, oh, 1974 must have been nothing before that. No, we had a Health and Morals of Apprentices Act, 1802. So you see, it's a very long time ago. And just opening it up in the middle, you see how the book is structured. There is the paragraph numbering. There isn't any footnoting as such, because all the information is contained actually within the actual paragraphs themselves. First class book. I think it's one of the best on the market, which is one of the reasons why I've reviewed it. So what do we say? Well, it's the most enduring and celebrated short work on health and safety work laws for all involved, and that's basically my view. I think it is. I'm delighted to review it again. It's always a pleasure to review Rachel's work anyway, and the annual edition is no exception. The new edition is the 25th. It's for 2016 to 17. I'm recording this at the beginning of 2017, this review. It's now appeared after the momentous decision for us to say bye-bye to the EU. The original text was written by the late Norman Selwyn, and it's now 40 years since the 1974 Act came into force. And as Teresa Budworth writes in the foreword, there is no doubt that the Act has had a major impact on health and safety in the UK and has saved many lives. Absolutely. And Rachel, of course, says the importance of health and safety cannot be underestimated, with compliance literally meaning the difference between life and death in extreme situations. How right she is. And I have to declare an interest. I have prosecuted on behalf of the HSE, so therefore I am bound to be fairly supportive of the views that are being put forward here, because these rules are here for a purpose, and I think if we didn't have them, we could have a lot of difficulty with certain people who run certain types of business. So therefore we have to have some rules. I'm not a great rule person, regulation person, but I do recognise the need. This is why this statement is probably the easiest to understand. It's not the easiest area of law to understand at all, but this book I think puts it in perspective. The reason then for this short law book's success, runs to just over 600 pages, is that it lies with the businesses and organisations who manage their health and safety issues well, because they're likely to be more efficient and financially healthier if they understand the rules. And this book, I think, helps every level of reader. The reason accidents and ill health can be a major cost to any organisation. Not just litigation, but all sorts of other factors come into it. Now, Budworth goes on to comment that the laws stated here underpin the work of health and safety practitioners who are often charged with helping their organisation to understand and comply with legal requirements. And that is where the beauty and the benefit of the book lies. It's a grasp of the principles of modern legislation which is essential for business, and the advice in this annual statement, I think, will be invaluable for a wide range of readers. I've mentioned them before. There'll be trade unions, safety officers, advisors, of course, all levels of the workforce. Anybody specifically tasked with health and safety matters. Teachers, for instance, have to know about it. So it's goal-setting legislation, as Budworth describes it, which places the responsibility on the creators of risks to find cost-effective solutions to control them. Now, that means, of course, you don't want to go daft, go be completely daft and over the top with it all, which I'm afraid sometimes happens a little bit. The fact of the matter is you've got to be sensible and proportionate in what is required and just lose a bit of common sense. But I'm afraid we have to have some form of framework. That's why I welcomed the 74 Act and the fact that even now it is working pretty well, because otherwise people would, for various reasons, mainly cost cutting, they would break the rules and people would suffer. I think it's also an important current statement on the law, which is not going to be immediately affected in any way by Brexit. However, many regulations have arisen to transpose EU directives. They are covered here. It's right to say that during the changes which are bound to occur with Brexit, it means that the regulations will remain in effect, and many can be considered to simply add more detail to the principles which exist in UK health and safety law from before we actually joined the EU in 1973 on the 1st of January. And we're sure this is correct, because business will find this little gem of a book just right for them during this tremendous period of upheaval which we're going to start this year, 2017. Now, obviously that's clear to me, but the benefit of this book is it's a book, it's an everyman book, every person book if you want to, but it does cover a very wide number of people. It's easy to use as well. Let me conclude, as the editor, as Rachel concludes in her most recent edition, we don't know what laws may or may not be changed, of course, with Brexit. But we do know one thing: the UK is already seen as a global leader on health and safety standards, so any changes are likely to try and reinforce that status. And that is probably exactly what will happen when Brexit bites. Whether it's a hard or soft option, looks like it's a hard one, as the anti-marketers will have had a success either way, because they won the argument. But many of our laws should remain intact. And I have to say, notwithstanding all the fuss, I think an awful lot of what we've got we will retain, and I think we should do. That's my own personal view, and I'm a Remain, so therefore, but not a Ramon, a Remain. But the point is that we should keep the most sensible bits for business without it being too onerous, and that obviously is where balance comes in. So I'd like to thank Rachel very much indeed for setting out and keeping the balance between the degree of risk and its management as we enter the 2020s. And as I say, the publication date for this book is cited at July 2016. Here it is again, front, spine, and then the back. A lot of detail there. And just opening it, Chapter 5, General Health and Safety Requirements, Employment Liability Insurance. I think probably you just see the structure of that paragraph number. I think just a last point, even though we're leaving Europe, it's not going to affect what we're doing, because this is common sense stuff. And as I said before, the first sentence talks about a piece of legislation in 1802. We've had it with us a long time, and we're always going to have it with us, so let's get real and recognise this is an excellent piece of, excellent book on what is actually an important and I think a pretty good piece of legislation. Thank you, Rachel. Thank you, Wolters Kluwer, as well, for continuing to publish this excellent work. All the very best to you. Bye-bye.